Good morning. Hope everybody's enjoying their breakfast. It's good to see everyone this morning. Thank you for taking time out of your busy schedules to join us on this post-election Wednesday. But you know, I guess that we were all just together yesterday as friends, and you know, some of us may still have some mixed feelings, and while this country is still divided on a lot of issues, the direction is clear. We must move forward full steam ahead with health care reform. And in our business, some things never change. Business leaders still find competitive health care and salary packages as their two biggest challenges. And we must now adjust. So let's get going with eyes wide open. And if you'd like a Bloody Mary, the bar is open in the back. So we have a lot of work to do between now and 2014, and Seacrest is here to help you. You see our values that we started some 6 years ago on the wall, and our mission statement: to earn the right to be a trusted advisor and advocate for our clients in all matters relating to risk. Our aim is to deliver upon this promise this morning, and no pressure on our speaker, Stacy, with today's topic: post-election, what happens now? And I'd like to introduce our speaker, Stacy Barrow. We do have a slight change in our speaker. Stacy works alongside Peter Marathis. Stacy is our go-to guy when our clients come to us with complex compliance issues. And Stacy comes to us from Proskauer Rose. Proskauer Rose is one of the country's oldest and largest law firms with 130 years of continuous service. Stacy Barrow is an associate in the Boston office of Proskauer Rose. He is a member of his firm's Employee Benefits and Executive Compensation Group and its Healthcare Reform Task Force. He uses practical, business-focused approach to counsel his clients on complex employee benefits and executive compensation matters. And as I mentioned, Stacy is who we go to when we have these type of concerns. Stacy's prior experience includes work as a compliance officer for an international insurance brokerage and risk management firm, and is also an actuarial analyst. So he covers both sides of the fence there in terms of compliance and actuarial work. And he did this for some Big Four public accounting firms. Stacy has spoken to business groups across the country on all matters relating to employee benefits, including national health care reform. He also has published numerous articles on employee benefits and national health care reform matters. Please welcome Stacy Barrow.
Morning, everybody. See if I can walk around a little bit. I think maybe I should lean like this, and then the slides will look straight. So my name is Stacy Barrow. I'm an employee benefits and executive compensation attorney with Proskauer Rose in Boston. We, of course, are proud to partner with Seacrest partners to be here today and to help them assist their clients in all manner of compliance with ERISA, COBRA, HIPAA, and unfortunately, PPACA. So, just a very brief introduction about our firm. It happens to be one of the oldest and most prestigious law firms in the country. We have just about 1,000 attorneys now in cities all across the world. And our clients range from very small companies to the Fortune 500s as well. We were the Facebook lawyers. My partner down the hall, we got to depose the Winklevoss twins. We also represent NFL, NBA, Major League Baseball, National Hockey League. Looks a little doubtful that we're going to have a hockey season this year if folks are curious, unfortunately. And we have a number of lawyers that are recognized by the various entities that rank and rate lawyers. We have 14 practices ranked on the national table at Tier 1, including our ERISA practice. We advise in every conceivable type of health and welfare plan, and pension plan, and retirement plan. We wrote the book on COBRA and national health care reform. We advise on all types of self-funded arrangements and ASO agreements that can help you negotiate your agreements with the TPAs and the carriers. And that's the commercial for Proskauer. I don't want to belabor it too much. So initial observations. Obviously, at this point, we know that President Obama has 4 more years. And the healthcare reform law will pretty much roll ahead as scheduled. I do want you to know that we had 2 different slide decks prepared for today. I wish I could have presented the other one. It would have been a lot more interesting. But this is our standard deck, which will discuss the law as it will continue to be implemented over the next few years. And this year, 2013, this coming year is going to be a very critical year for employers in terms of planning, particularly if you have a large number of part-time employees. This is the year to consider how that's going to affect you in 2014 and beyond when we have the employer mandate, that pay-or-play mandate. The Affordable Care Act is not health care reform, it's really health insurance reform, as you probably have figured out. And the cost of providing care is really not seriously addressed under health care reform. We've seen how the direct costs are going to increase with the premium increases and taxes and penalties for non-compliance, but there are also some indirect costs as well, the administrative costs and of course the unrestrained agency action. We have heard that the regulators were basically sitting on a bunch of regulations that they're going to release post-election, and we imagine that they were sitting on them because they probably weren't all that employer friendly. So expect to see maybe before the end of the year some new regulations that come out, possibly on the non-discrimination rules that have been delayed up until now. But that's what we think might be coming up in the next few months. The key components of healthcare reform obviously are the individual mandate and the subsidies and the penalties that go along with that, and then the insurance mandates and the employer mandates, and of course the exchanges. And it's really somewhat of a 3-legged stool. It's really the individual mandate, the employer mandate, and the exchanges that's intended to kind of come together and cover all of the uninsured or underinsured folks, depending on what estimate you look at, either 30, 40, or even up to 50 million people that are underinsured or uninsured. So I want to run through some of the mandates, and I want to start with the individual mandate. This is part of the individual mandate, and folks having to obtain and maintain this minimum essential coverage is going to be what could potentially drive penalties for employers. So that's why I want to kind of go through the rules regarding the individual mandate. So obviously this starts in 2014, and it essentially requires all adults to have some form of health insurance. Any number of types of insurance can qualify, including Medicare, Medicaid, employer-sponsored coverage, individual plans, VA coverage. Basically, almost any group health plan an individual enrolls in will count as satisfying his obligation under the individual mandate. It doesn't really matter the quality of the individual's coverage. As long as he enrolls in the plan, he won't be subject to a penalty. Penalties are generally pretty low for the first few years of healthcare reform. It's a bit of a sliding scale. There's a flat dollar amount, and it increases. Well, it's $95 per adult, and then it's halved for children under 18, and that's true for all of the flat dollar amounts. But it's also the greater of that flat dollar amount or percentage of income, and it goes up in 2016 up to 2.5% of family income. So it does have some teeth in later years. There is a subsidy available to purchase the health insurance through the state-run exchanges. Generally, to be eligible for a subsidy, you have to be a legal U.S. resident. Your income must be high enough that you're not eligible for Medicaid, but low enough that you're still eligible for a federal premium subsidy. That's generally going to be between 133% and 400% of the federal poverty level. But it will dip down to between 100 and 400% for states that don't expand Medicaid. And we're going to talk a little later about what that means for employers if you're in a state that has not chosen to expand Medicaid or declines to expand in 2014. The 2012 federal poverty level for a single person is $23,050. 400% of the federal poverty level for a family of four is nearly $90,000, or it might even be over $90,000. So as employers, you're going to have some employees that fall into that bucket that could potentially be eligible for a subsidy if they're not offered quality, affordable health insurance, and we'll get into exactly what those terms mean in a little bit. The subsidy is provided on somewhat of a sliding scale based on income. Obviously, the lower income you have, the greater of the subsidy you have. And in addition to these premium subsidies, there are also cost-sharing subsidies. So if you're very low income, not only do you only have to pay a small portion of the premium, but you'll have additional cost-sharing subsidies to raise the value of your plan. In terms of the exchanges, as you know, the states are required to establish an exchange by 1/1/14. They have to demonstrate to the government that they're underway by 1/1/13, and we have a number of states, and I have listed them in a couple of slides, that have come out and said we are going to build an exchange or we're not, or we're still deciding. But there's really two types of exchanges. There's the American Health Benefit Exchange, which is more for individuals, and the SHOP exchanges, the small business health option programs for individuals and small businesses to bridge the gap between the small groups and the insurance companies. And this allows employers to facilitate their employees going into the exchanges. And if the employer participates in this SHOP plan and makes some minimum contributions, they'll be insulated from the penalty, the employer mandate penalty. There are a few different types of exchanges. There's a state exchange, partnership exchange, and federally facilitated exchange. The state exchange, very simply, is an exchange run by the state. The partnership design, it kind of bifurcates the responsibilities for the exchanges between the state and the federal government. The government takes the parts that they're good at, and the state takes the part that it's good at in terms of managing the rates and the insurance products. And then the federally facilitated exchange is what happens if the state declines to come out and establish a state-based exchange. And we'll talk about what happens when the feds come in to run the exchange, and what happens with respect to the federal premium subsidies and how that might impact an employer under the employer mandate, because in this 2,800 pages of healthcare reform law, there are some vague and inconsistent provisions, if you can believe it. So will the states be ready? And this is obviously a huge question as employers gear up for 2014. 18 states are actively considering or have already established some form of exchange. You can see Mass up there. That's where I practice. We've had our own form of healthcare reform now for about 5 or 6 years. We have our own exchanges. We call them the connector. And I guess our experience in Mass should be pretty instructive for the rest of the nation. I know it's a pretty small scale up in Mass, but I can tell you from our experience, for example, we had 95% of our state covered under some form of health insurance back in 2006 when we started healthcare reform. And now, 6 years later, we have 96.5% of our state covered under some form of health insurance. So we've increased access a little bit, but it's also resulted in higher costs. Our trends are well above the national average. Our state likes to deny insurance companies requests for rate increases, which obviously just puts more pressure on the insurance companies. And we've also seen a shortage of primary care physicians for some reason. I'm not exactly sure what drives that, but that's been another unforeseen effect in Massachusetts. Another 16 states are studying their options. They haven't come out and declared a position either way yet, but a number of states have either had no activity or just declared outright that they will not be establishing an exchange, and have, in some cases, have dared the federal government to come in and establish one in their state. And it's interesting to know that half of the uninsured live in about 6 states. 2 of them are declaring that they're not going to establish an exchange, and I guess one of them is Georgia, and you guys haven't really declared either way yet. I don't know if anyone in the room has any idea where Georgia stands on the exchange issue. If you do, speak up. It'd be great to know. So what happens if a state fails or refuses to establish an exchange? And we have the flag of Texas here because that's, I think, one that has come out and said very clearly that they're not going to. This is the text of a letter from Rick Perry, the governor of Texas, that he sent to Catherine Sebelius, essentially talking about how the Medicaid program, as Justice Scalia said, was putting a gun to the head of the states to get them to accept this this expanded Medicaid program, which the Supreme Court said was different than every other expansion ever to have been passed through Medicaid, and that this one was so great that it fundamentally changed the nature of the Medicaid program, and therefore it wasn't just like a simple expansion like it was in the past. I'm not sure if I buy that argument, but it's at least colorful. And so Rick's position here is that the intrusion of the state exchanges, the forced state exchanges in his state, is an intrusion into the sovereignty of the state, and he does not plan to institute a state-run exchange. And I'm not even sure if the federal government will be successful in opening up an exchange in Texas. Once you're in the exchanges, the plans in the exchanges are required to offer the essential health benefit package, which includes some degree of coverage for all these 10 levels of benefits here. Our group health plans and the employers that serve your group health plans, they don't have to offer all of these essential benefits. They don't have to offer the essential health benefit package. You just have to, it's just for plans in the exchanges. However, if you offer any of these services in your plans, then they must comply with the lifetime and annual limits under PPACA. So it's important for us as plan sponsors of large group plans and self-funded plans to at least be aware of what benefits are included here, because your plans will have to comply with them from an annual limit standpoint. And these include, the basic litany of services like hospitalization and prescription drugs, and if nothing else, it taught us a new word, habilitative. I didn't know that existed before the essential health benefits came out. And the states have some leeway in terms of setting the eligibility for the exchanges. Prior to 2016, a state can limit the definition of a small employer to 50 employees or less. And then in 2017, the state's ability to limit small groups under 50 goes away, but still only small employers can participate in the exchanges. And then in 2017, they're opened up and anyone can participate. This is kind of like what we did in Massachusetts, except in Mass, we actually broke our own law and permitted large employers to enroll immediately, because as you would expect, when we opened up our version of the exchanges, we had massive adverse selection. Only the sickest and the poorest of our state's residents were interested in enrolling into the exchanges, and so we had to let the large employers join as well, just to get some more bodies in the pool. The exchanges did learn from Massachusetts when we first instituted our exchange, our connector, if you will. There was no real open enrollment period. You could simply enroll in a connector plan whenever you wanted, and you could drop it whenever you wanted, and you could re-enroll whenever you wanted. And of course, this had the effect that you can imagine that people took the care when they needed it and then dropped it when they didn't. And even to further aggravate that situation, in Massachusetts, our individual mandate doesn't kick in until you have more than 3 months of no coverage. So you could really manipulate the system here. Not only could you get the care for the month you needed, essentially, but you could drop it and pick it back up again in a few months, and you still wouldn't have a penalty. So the exchanges learned from this, and they're going to have an initial open enrollment period, and then in later years, it's going to match the Medicare open enrollment period. And of course, there will be special enrollment periods, just like under HIPAA, for your group plans, in the event that somebody gets married or has another type of HIPAA special enrollment event. The plans in the exchange are going to be offered according to 4 different levels of coverage. They're tuned to the precious metals, bronze, silver, gold, and platinum. The percentages you see there are the actuarial value, or is the actuarial value of the plan. Actuarial value is a term that we're probably going to have to get a little more comfortable with over the next few years as more employees are enrolling in the plans and the exchanges come into fruition. Actuarial value is just a way to roll up the level of financial protection offered by your plan into like a number grade, 60, 70, 80, 90, and the percentage is basically how much of your healthcare costs the plan expects to cover across an average population. So to give you an example, say you have a plan with a 60% actuarial value. The 60% plan is intended to cover, on average, 60% of the participants' claims or healthcare across the whole population, given the low utilizers and the high utilizers. So a low utilizer, say someone who never goes to the doctor, hasn't gone the whole year, but sprains his ankle and needs to go to the doctor in December. He's a low utilizer. He probably will be responsible for 100% of the cost of his care because he hasn't hit his deductible yet. On the other hand, someone who's a high utilizer who may have had some heart surgery, he will pay much less than 60% of his cost, or the cost of his benefits, because he'll hit the out-of-pocket maximum, or things like that. So that's how the actuarial value is determined. It's not based on actual claims experience. It's more of basically just a projection of what the plan expects to pay, given a standard population. I'll have low claims in most here than high claims at the other tail. There's also a catastrophic plan for young adults, and they call that the TIN plan. It has an actuarial value of under 60%. And the insurance companies are permitted to offer coverage both inside and outside the exchanges, but they aren't permitted to undercut their own exchange plan. So they can't offer a plan outside the exchange that's basically literally the same as an exchange plan, but for a cheaper or a less expensive premium. So I want to move now away from the individual mandate and the exchanges and get into a little bit of the employer mandate. And one of the provisions that is intended to dovetail with the employer mandate is this 90-day limit on waiting periods starting January 1st of 2014. This is one of the rules under PPAC that applies to all plans, including grandfather plans, and it limits waiting periods to 90 days once someone's eligible, and that's a hard 90 days. It's not first of the month following 90 days, at least how the law is written. We'll have to wait to see how the regulators define the regulations, but right now it's a hard 90 days, and there's some, these rules regarding the 90-day waiting period and the employer mandate, they're very complex and they're very technical, but what they're designed to do is give us a way to figure out ahead of time which of our employees could potentially cause a penalty under the employer mandate. And that's what this last bullet here basically is giving us some leeway in order to take enough time to figure out whether someone really should be eligible for the plan and not subjecting the employer to a penalty during that phase when they're trying to figure out who's eligible for coverage. So this is the big mandate in 2014, and like I said earlier, 2013 is really the time for planning to figure out who are your full-time employees for purposes of this mandate. So very basic, the rule here is that if you have 50 or more full-time equivalent employees, you are now a large employer for purposes of the mandate. This concept of full-time equivalent is only applicable to determining whether you're a full-time employer, a large employer. Once you're over the threshold of having 50 employees, then the concept of a full-time equivalent no longer applies, and you're either going to be a full-time employee or a part-time employee. And the general rule is that once you're a large employer, if you're an applicable large employer, you have to offer coverage to your full-time employees and their families, and failure to do so can generate a penalty if any of your full-time employees becomes eligible for a federal premium subsidy and goes out to the exchange and purchases coverage through the exchange with a combination of their own money and the federal subsidy. And plenty of our clients and employers that I've talked to, a lot of them are basically going to call the government's bluff on this one and say, look, we just don't think that our employees are going to take their own money and go out and get coverage through the exchange, even if they get a fairly substantial federal premium subsidy. And so you should potentially take that into account when you're thinking, you're planning for next year. So the key to an employer penalty under this mandate is if a full-time employee receives a subsidy in a state exchange. And there's a question here as to whether a federal exchange that was created in lieu of a state exchange can still be used for these purposes. The law is very clear and very plainly stated that the subsidies are only good for a state exchange. And so obviously the first employer that gets hit with a penalty because the employee got coverage through a federal exchange will likely sue over this, particularly if it's hundreds of thousands of dollars in penalties. They will likely challenge this in court. The regulators, the federal government, has already come out and said that their position is that for these purposes, a federal exchange is a state exchange. But if that were the case, they should have said that in the law, and the place to correct that is not in the regulation, it's to amend the law. And folks would argue that they're stepping over their authority, the regulators, when they take the position that the word state means state and federal. So again, and this is, we're just talking now for a second about whether you're an applicable large employer. And so to be a large employer, you have to have 50 or more full-time equivalent employees. And so for this purpose, to determine whether or not you're over 50, you take your full-time employees, anyone working 30 or more hours, so whether you're working 30, 32, 35, 40, that's one person, and then you add to that the total of the sum of the hours of service of part-time employees divided by 120. And if that number adds up to over 50, then you're an applicable large employer and you are in the employer mandate. You're now subject to the employer mandate. But that's only for purposes of determining whether you're a large employer. If you're over 50, you can forget about this number, or this 120 hour of service number. I know this gets confusing because when we talk about part-time employees, you're going to hear me refer to a 30-hour per week or 130-hour per month standard. That's the one you really need to think about for most of you in the room. There's a special rule for seasonal employees, and those are people who are truly seasonal employees as defined by the DOL. They're only hired for certain months per year during a company's busy season or during certain holiday seasons. But you can basically use a good faith definition of seasonal for the next couple of years. And there's just a special rule here that if you're under 50 employees and your seasonal folks push you over the limit to the applicable large employer, then there's an exception for those types of employers where they would ordinarily be small but for their seasonal employees. Gives you a little bit of an out there, but it's a very narrow exception. So once we're subject to the employer mandate, there are two types of penalties. There's two penalty regimes here. There's what we're going to refer to as the $2,000 penalty and the $3,000 penalty. The $3,000 penalty is actually less than the $2,000 penalty. So already, you can tell where this is going. So the $2,000 penalty is applied to employers that have completely opted out of offering insurance. They've decided for whatever reason it's no longer economically viable, they're not going to offer through health plan, and they're going to encourage employees to maybe go into the exchanges, or they're going to just abdicate entirely. Maybe they're going to continue to offer ancillary benefits, which is obviously a huge question because the exchanges only offer health insurance. And so, an employer that puts its employees into the exchanges will still have to deal with all the ancillary benefits and all that good stuff. But at any rate, this $2,000 penalty is intended to cover employers who opt out of providing coverage. And this $2,000 penalty is based on, is per employee, even if only one employee goes to get a federal premium subsidy for the exchange. So let me restate that. So if you don't offer coverage to your employees and you have one employee that goes and gets a federal premium subsidy from the government and then goes to the state exchange and uses part of his own money and gets the coverage, then it triggers a penalty on the employer of $2,000 for every full-time employee that the employer has, even if only one employee goes to get the subsidy. And this is the penalty for employers who opt out. And obviously this one is pretty significant. So there's a question of what happens if you offer coverage to only half of your full-time employees, or 75%, or 99%. At what point do we get out of this penalty regime into the other one that's a little less extreme? And we just don't know yet. The law is written very oddly. You can see that this is almost a quote from the law that you have to provide health coverage to all full-time employees and their dependents. And they don't define dependents in here. And because the rule is in the tax code, when you don't define dependent, you revert to the tax code definition of dependent. So really, is the government saying we have to provide coverage to anyone who's dependent? Even my uncle who might be living with me, or a grandparent that we take care of, that we get a tax deduction for, that would be absurd, right? We don't think that's the way it's going to work, but we obviously need implementing regulations to flesh all this out. And even further, there's no mechanism for penalizing an employer that only provides single coverage. If you provide single coverage and it's affordable, then your employees can't get a federal premium subsidy, and even if you don't offer coverage to the family members, there's no mechanism to trigger a penalty. So all this is going to have to get fleshed out sometime next year. And those of you that have been paying attention to some of the guidance that's come out from the IRS, you know that we've received guidance on full-time employees and the waiting periods, but that's just in the form of an IRS notice. That's not a regulation, and there's gaps in that too that they recognize even within the IRS notice. They say, look, this is simply a safe harbor. You can avail yourself of this if you want. If you don't want to, you don't have to follow these rules. We recognize that there are some gaps here, but use your best judgment in applying them. So we desperately need regulations. So at any rate, it is a monthly penalty. It's $167 per month, which is $2,000 a year. So if you were to opt out, you'd be potentially subject to a penalty of $2,000 for every full-time employee over the first 30. There's an exception here for the first 30 employees for relatively, it helps the smaller employers. But that's how this penalty works. The second one is much more likely, I think, to affect the employers in this room. And this is a penalty for providing coverage that is either unaffordable or doesn't meet the minimum quality standards that are specified under healthcare reform. And so if the coverage is quote, unaffordable, then the penalty here is only $3,000 for each employee who obtains coverage through a state exchange. It's not, it doesn't apply to all full-time employees regardless of whether they get a subsidy. It's only for each employee who actually goes out and gets one. And so this is where some employers are going to maybe gamble a little bit and say, well, look, I'm not going to drop my premiums so low that the coverage will be affordable by the government standards. But if any of my employees decide they really need the coverage, they go out and get it, I'll pay a penalty of $3,000 for that employee. And that's a lot more palatable than $2,000 per every full-time employee. So what does it mean to have quality, affordable health insurance? The affordability piece is linked to the premium cost. And very simply, coverage is affordable if the premium for employee-only coverage does not exceed 9.5% of W-2 wages. The way the law was written, it referenced household income, and employers were concerned because a lot of them didn't know the household income of their employees, and why would you, and why would you want to? It only raises the potential for employee relations issues and discrimination claims when an employee doesn't get the bonus they expected, and so they say, well, look, you know, my spouse is well paid, and therefore you chose not to bonus me, and you're discriminating against me. So the regulators gave us an out here, and they said instead of using household income, you can use W-2 wages as your benchmark for that 9.5% measure. It is better for the employee because W-2 wages are lower than household income, and it's better for the employer because they don't have to play detective and figure out everybody's household income. So the affordability measure is linked towards the cost of single coverage, and the minimum value measure is linked to that actuarial value that we talked about before. As long as the plan has at least a 60% actuarial value and the premiums for single coverage don't exceed 9.5% of household income, then none of your employees can trigger a penalty, even if for some reason they're ultimately eligible for a federal premium subsidy. That's what you're saying on this one.
Before we close that pay-play piece is very, very important. And through our association with BAN, Benefit Advisors Network, we also work with Stacy. We also have a formula tool to help you with the full-time equivalency process and what goes into building really what Stacy just shared here. We'll be working with you over the course of the coming year to assist you with that mix.
Yeah, and that's BAN, Benefit Advisors Network, which Seacrest Partners is a part, developed a very robust Excel-based modeling tool to help employers figure out the economic impact of either paying the penalty under one of the two regimes or exiting the market entirely. And it's not as easy as just kind of a binary tricky decision here. There's a lot that goes into it. There are the penalty is non-tax deductible. It's an excise tax. When you pay for the premiums for employees' insurance, it is tax deductible. When you no longer have pre-tax contributions, you lose the FICA savings. So there's a number of factors that get included in this model is very robust, and it will be useful for some folks to use to figure out what their likely penalty could be under this pay-or-play mandate. Recently, we did receive some guidance from the IRS to attempt to clarify what a full-time employee is for these purposes. And like I said, the rules are very technical, they're very complex, but if you follow them closely, it will enable you to figure out ahead of time who could potentially cause you a penalty under the employer mandate, and then you can take action, whether it's to make that class of employees eligible for coverage or some other action, but at least you'll be able to know ahead of time before a penalty is imposed. And so the IRS introduces this concept of the variable hour employee. And if on your date of hire you are reasonably expected to work at least 30 hours a week for the year, then you're going to be considered full-time for purposes of the mandate. If it's not known when you're first hired whether you're reasonably expected to work 30 hours a week, then you'll be considered a variable employee for purposes of this IRS guidance. And again, this is just a safe harbor. You don't have to use it, but if you use it, then you'll be insulated from a penalty if you follow these rules very carefully. That's not to say another method that you come up with as an employer would not be respected by the IRS. They certainly might accept any other methods. And not everybody bases eligibility on hours. There are still some employers out there that base it on maybe sales or commissions or products developed. So there are other factors for eligibility that don't fit in nicely to this safe harbor. So I do believe that the government will recognize other methods of determining full-time employee status. So I don't want to get into the technical details too much, but I'm going to briefly explain how this works so you can think about it and talk it over with Steve and his team. And this is really probably of more import to employers with a large number of part-time employees. But the way it works is there's going to be a look-back period and a subsequent stability period. The look-back period is chosen by the employer, and it's between 3 to 12 months. You pick it at your election. Whatever works best for your organization, you choose that look-back period. And then after the look-back period, the next subsequent months is called the stability period. And the stability period is the same period of time as your look-back period. So if you took a 6-month look-back period, then your subsequent stability period is 6 months. If you took a 12-month look-back period, the stability period is 12 months. And what that means is when you look back and you figure out over the last year which of your employees were full-time, if they remain employed during the stability period, then their determination from the look-back period carries forward. So if I was determined to be a full-time employee during the look-back period, which is 2013, for my employer, then for all of 2014, I'm a full-time employee, even if my hours dip down below 30 or 20 or whatever. And of course, that raises the question of, well, how does the affordability measure get affected then? If I was a 40-hour employee and now I'm working 15 hours a week, obviously my premiums will probably be above 9.5% of my wages since I've cut them from a 40-hour week down to 15 hours. And that's just another unanswered question that the regulators will have to answer for us. Perhaps they'll let us use the prior year's W-2 earnings, but it's really anyone's guess at this time. So that's kind of how it works. So if you have a lot of part-time employees that fluctuate above or below 30 hours, you can use 2013 as your look-back period and figure out which of those part-time employees are going to be full-time for purposes of the mandate. And there are a lot of nuances to these rules. We recommend that if you're in that bucket and you're concerned about this, talk to Steve and his team, and we can walk you through this in a one-on-one type of situation. So as I alluded to before, there's some possible employer action here. We expect to see some employer lawsuits over this issue of whether a premium subsidy can be used in a federal exchange or if it's only reserved for a state exchange. And as you can see from our slide, really the IRS they're quote, clarifying the law that it really is intended to apply to state and federal exchanges. And our question is this is really legislating at this point. I mean, the correct way to fix a law that has an inconsistency is not through interpretive regulation, it's through amending the law. And we don't see a huge likelihood of the government amending PPACA to change the wording there. So it's going to just be decided by the courts, basically. I want to talk about the Medicaid expansion for a couple of minutes just because it is important to employers. I believe Georgia is one of the states that challenged the Medicaid expansion under PPACA. I'm not sure I have a slide on it. And yeah, so you are. So since Georgia was one of the states that challenged Medicaid expansion, it's probably fair to say that they're not going to expand Medicaid. They still might, but most likely they probably won't. And so what does this mean to employers? So if the state expands Medicaid, it brings a whole new class of individuals into Medicaid eligibility, and it basically saves them from the employer mandate. All of these individuals between 100% the federal poverty level and 133% the federal poverty level are squarely those who would be eligible for a federal premium subsidy. By putting them into Medicaid, you remove them from the ability to get a federal premium subsidy, and therefore they cannot trigger a penalty on the employer. Now, if the state doesn't expand Medicaid, then all of those individuals that would have gotten picked up by Medicaid will now potentially be able to impose a penalty on the employer if they go to the exchange, get the coverage, and they're full-time employees. So the court did strike this down as unconstitutional. It was actually a 7-2 vote. They even got the liberal judges to agree with them. And Scalia said it was essentially the equivalent of putting a gun to the head of the states. The law said that if you don't expand Medicaid, you lose all federal funding for Medicaid. And that's the way previous Medicaid expansions have worked. The government has always used the stick approach and said, look, it's voluntary, but if you don't voluntarily do it, we're taking all of our money back. And so the court said here that this was just way too extreme, and you can't claw back all of the money from the state Medicaid coffer, only the expanded or the increased funds that were coming in through PPACA. And so these are the states that argued against Medicaid expansion. Be interested to see the electoral college map overlay over this. But yeah, so this is a map of the Civil War. I mean, the Medicaid expansion. But moving on to a more fun topic, audits and agency interaction with the employer. We do expect that you'll see an increase in agency audits, whether it's DOL or IRS, HHS, Treasury. We have already seen that the DOL has added elements of PPACA to their audit list when they audit employers' plans. We've also heard that any 401k audits will also now be expanded to the health and welfare side. I don't know if that includes existing audits, but our understanding is that in the future, that the K plan audits will also encompass health and welfare benefits.
I do want to mention also here that we have seen this here locally with one of our larger clients. We have experience in this realm, having gone through it and come through the other side with what was a good report. So we do have a talking document that we can work you through on a fire drill basis to determine where you are in relation to the DOL requirements and these regs.
Yeah, it's definitely good to work closely with Steve and his group, and they'll make sure that you have everything you need for when the government comes knocking. And certainly, to the extent you have all of your documentation available and ready, and you have your, whatever, if you're subject to HIPAA, you have your HIPAA manual, you have your SPDs, and your plan docs, and your old 5500s. To the extent you have all this prepared and you can give it to the auditors in like a notebook, they have a tendency to either go away or to take a much less heavy-handed approach. If they come in and you have nothing to show them, they're going to stick around a while. But I do know that when we help our clients develop the audit book to return to the DOL, they rarely come back with any additional questions, and it's something very minor. They might suggest an additional sentence here or there in the SPD. But perhaps one ray of sunshine for employers is that in the early years of enforcement of this healthcare reform law, the DOL is focusing more on increasing employer compliance rather than simply dinging employers $100 per employee per day for any random violation. And it's important to note that in addition to the DOL audits, there are other enforcement mechanisms for compliance with laws like COBRA and PPACA, and HIPAA, and Mental Health Parity Act. There's Form 8928, and I don't expect that a lot of you have heard of this, but it is a self-reporting IRS form that actually predates PPACA. It's been around since 2010, and employers are expected to self-report failures with certain laws like COBRA and HIPAA and mental health parity and penalize themselves $100 a day. And if you don't do the self-reporting, if it comes up on audit, the penalty is a lot higher. It's up to $1,000 or $1,100 a day. I do encourage you, if you've had compliance failures, to work with counsel and complete the Form 8928, because there's an exception for mistakes that have been corrected and that were not due to willful negligence or intentional disregard of the rules. And if you follow the instructions, then you fill out the Form 8928, but there's no dollar penalty, there's no reporting penalty. You just put in zeros where the penalties are. And that starts the statute of limitations running. And after 3 years, the government can no longer challenge your determination that, yes, we did fix this to the extent possible, and therefore we shouldn't be penalized. If you let it go and you sweep it under the rug and it's discovered on an audit, then you no longer have the ability to get away without penalty. So we have helped plenty of clients through the Form 8928 process. Just to give you an example of something that could come up, this maybe happens if you're self-funded. We had a client switch TPAs, and the new TPA took the list of the folks with creditable coverage, which obviously dates to their start in the plan, and they wiped out those dates and put in the new effective date of the new TPA. And so folks are getting creditable coverage notices when they terminate that showed their coverage was only creditable as of, say, 1/1/2012. And that's a HIPAA failure. And so we corrected it, we filled out Form 8928, and the client put down zeros for the penalty. And they were a major employer, they already had audits going on, so they felt it was worth it to go through the correction process, even though only a few people were affected. They went through and really corrected it because they wanted to avoid any possibility of that penalty. Then, so of course, in addition to the regulatory action, we could see participant lawsuits as folks seek to take advantage of these mandates under PPACA, and employers are still struggling to get up to speed with them, given the depth of the regulatory guidance. Another couple of things I think is important to mention. When we first talk about healthcare reform to a lot of our clients, they go through what I like to call like the 7 stages of grief. where you start out with denial, and then anger, and then bargaining, and then eventually you get to acceptance. And so the first thought for a lot of employers, particularly those with large part-time employee bases, well, I'm going to realign my workforce, and I'm going to make sure that everyone is limited to, that I don't want to give coverage to 29 hours a week. So they'll be part-time, and I won't have to worry about this. And that is potentially a viable solution if you can continue to operate the business that way. But anytime you do a workforce realignment like that, you should talk to Labor Council, talk to Benefits Council. You have to be very careful about how you describe this to your employees. If you just come out and say, look, Obamacare is forcing me to cut your hours to 29 hours a week, you are opening yourself up to potential class action lawsuits under ERISA. It's potential interference with benefits under Section 510 of ERISA. So you do have to be very careful about how you parse this and how you explain this to your employees if you're cutting folks' hours down to, say, 29 hours a week. We've seen an increase in folks and employers trying to exit the retiree medical market. Just be aware of what promises you've made to your employees. If you have retiree medical, retirees tend to get very litigious about their benefits. And of course, claims to mandate benefits and whistleblower actions. As people become more aware of what their benefits should be under the law, they may seek to try to enforce them and avail themselves of them under the plan. Steve, should we take a...
Yeah, I was wondering, I'm just thinking it might be a good time for a break. Take about a 10-minute break and come back, and then Stacy will wrap up his discussion. But we do.
So I do want to thank you all for bearing with us on what is somewhat of a dry topic. But now that I've gotten all the boring stuff out of the way, I'm going to move on to the insurance mandates and market reforms. So obviously, as we've talked about, the insurance mandates under PPAC and all the market reforms that we've heard about over the last few years, like the lifetime limits and coverage of adult children, and all that good stuff is all going to continue to roll forward. This year was the first year that employers saw the medical loss ratio rebates. This is one of the elements of healthcare reform that is touted as making care more affordable, and we were all very surprised at the volume of the medical loss ratio rebates. We had kind of an internal bet around the office that no one would see rebates under this rule, but we had some clients, very large clients, that were seeing tens of millions of dollars in rebates. So they're out there. This medical loss ratio rule, if you don't know already, requires insurance companies to spend a certain amount of every dollar on healthcare claims or healthcare improvement activities. For large groups, they have to spend 85 cents on the dollar, and for small groups, it's 80 cents on the dollar. And those of you that are members of multi-employer plans or self-funded plans know that your plans are much more efficient than this, and you're typically probably spending much closer to 95, 98 cents on the dollar on medical claims. And that's another one of the benefits of self-funded arrangements. If you did receive a rebate this year, the most important thing is that you had 3 months to distribute it to employees, at least the portion that's allocable to employee contributions. The rebate is intended to be apportioned based on the employer and employee premium split. So in general, if the employer pays 80% of the premiums, they get 80% of the rebate, and the employees get the other 20%. The employee rebate is typically provided in the form of a premium reduction or a cash payment. Most of our clients ended up providing it to current participants only in 2012, although we had a number of clients that actually decided to provide it only to those who were on the plan in 2011, because that's the year that generated the rebate. And really, any reasonable allocation method should be respected by the DOL. we just recommend that you very briefly document the process. You can say you got the check on August 5th and you allocated it to all current participants and then sent it out on September 15th. Something like that, just very briefly, just so in the event that an auditor ever comes, you can say, yeah, we did document the process, and this is why we chose this particular allocation method, and so on. The summary of benefits and coverage, I think you're all probably fairly familiar with this. This is another new requirement. It's in effect for your open enrollments for 2013 and for your 2013 plan year. This is the uniform summary of benefits and coverage. And I say uniform because it's intended to be the same among employers, except for the differences in the financial protection offered by the plan. So what you should be able to do is pick up your employer's SBC and maybe your spouse's SBC and very cleanly kind of run down and see the differences in the plan designs. And this is intended to be immensely useful. In reality, they're more like snowflakes. And I've looked at 1,000 of these things, and I don't know how they've gotten so far removed from the model and the instructions, but it's impressive. And the carriers are very reluctant to make changes, but at any rate, if you're fully insured, you can basically rely on the carrier's version of this, unless it's so facially deficient that it doesn't even really reflect your plan design. We've seen a couple like that. This was originally intended to be 4 pages under PPACA, and when the regulators got a hold of it, they said that, well, the government and the Congress must have meant 4 double-sided pages because we can't possibly fit all this stuff onto 4 pages. So overnight, it became 8 pages. Now it's the 8-page summary of benefits. Personally, I thought that the carrier documents, those little benefit highlighters, I thought those were very useful. And I think a lot of the employees, that's what they really look to, unless they need to really dig into the benefits offered by the plan. So I wasn't sure why we needed this, but at any rate, it is upon us. There are some non-duplication provisions, and that's the second to last bullet there. When you're handing out these SBCs at enrollment or open enrollment, you only have to give employees the SBC for the option they're currently enrolled in, unless they request other options. For a new employee who's newly eligible, if he's eligible for, say, your HMO and your PPO and your high deductible plan, then he should be provided an SBC for each of those benefit options. The requirement does apply jointly to plans and carriers, but the carriers are statutorily obligated to produce these things. Whether the employer requests it or not, and regardless of what the employer does. And so we've seen carriers that have taken a position or that have encouraged clients or requested that they sign some form of indemnification saying that, if the employer fails to distribute these or if there's any mistakes, that the carrier is indemnified. And we certainly would recommend you talk to counsel before you sign anything like that. And frankly, I wouldn't sign it. They're required to do it. They should do it. You don't need to indemnify them for them to produce these things. Oh, sure. Let me restate the question too so everybody can hear it. And please definitely feel free to speak up, and I'd like to make this as interactive as possible. So if you do have questions, let us know. But so the question was, are there any applications or software products out there that might automate this process, but either maybe with regard to the SBCs or the employer mandate, or just kind of figuring out who's a full-time employee? And I'm not aware of any that really automate this process. I mean, part of the problem is we don't have implementing regulations yet. So, all we're talking about is kind of the planning phase, and we can't really reduce it all formulaically yet, just because we don't have the proper guidance. There is some, so say if you're self-funded, you need to put together the SBC yourself, and your TPA might not be helping you.
I'll just jump in there. As far as the self-funded client that we're engaged with, we align closely with the TPA that's involved, using their model, using our input to build the SBC with you to jump into this space. And as Stacy mentioned, as far as the fully insured carriers, what we see is typically they jump in and provide the SBCs, but from a self-funded standpoint, we assist our clients with the process. And then the other piece you were talking about, I think you touched maybe on the pay-or-play modeling tool, that we also have a tool that assists in that space.
And that is really just a model. It's not, you can't kind of rely on it. It's only as good as the information you put in and the rules that you have when you build the model. And so it's tough to have an automated process for that at this point. Is there a question? That's right. So one of the thing.
Formula's wrong.
Yeah. One of the things that the government has given us is a tool to create the coverage examples, but there are some issues with it where it doesn't produce the right numbers, which leads me to question, the carriers are using the same tool, right? So, we've seen these, and some of our more eagle-eyed clients have looked and said, this doesn't sound right. Is it really going to only cost this amount of money? And then you go back to the carriers and you ask them to kind of support what they've been doing. And when you dig into that little spreadsheet, it does have some issues. I've looked at it in a while, maybe it's resolved, but probably not, is what you're saying. Okay. So there are tools that are put out by the government, but they only work. They only work in varying degrees. Another tool the government's going to put out is an actuarial value modeling tool, where you put in the pertinent information for your plan design, your co-insurance and deductibles, and it will spit out an actuarial value that you can rely on for purposes of the employer mandate. But just to answer your question, I'm really not aware of any software that can take this out of your hands so much, although the software I see is mostly modeling to kind of prepare yourself for the mandates. This SBC requirement comes with its own penalty. This is under healthcare reform, almost all of the mandates, the penalty is $100 per affected employee per day. This one is $1,000 per affected employee per day. So they're very serious about getting this SBC out, as you've seen the carriers scrambling to get these out. You're permitted to include it in other documents if you want to make it into the SPD. If you want to include it with open enrollment materials, that's fine. We do recommend that you make it as prominent as possible. If you're going to include it with other materials, it should appear no further back in the document than the table, after the table of contents. It should really be the first thing they see. And thankfully, premiums are not required to be disclosed in the SBC. That would have, quadrupled everybody's SBC burden, because a lot of us use, tier-banded rates, and thankfully, you don't have to put those on there.
Stacy, on the SBC, the distribution this year, do you think that you get the movements of it, which works that we've been dealing with, it's been a challenge to get those out as soon as the guidelines state, but if you're in a good faith compliance mode, you're doing everything possible to get that passed to Congress, what you're thinking on that?
So it's a good question. So Steve mentioned, what if despite your best efforts, the company is not able to send these SBCs out. Maybe the carrier delivered them late, or they underwent some changes and you just couldn't get them out on time. You should still get them out as soon as possible once they are completed. But the DOL is really, for the first few years, they're going to look at good faith efforts, and they'll go a long way. And certainly if the carrier if they delivered your SBC the day before your open enrollment, and you haven't had time to review it, I think it'd be reasonable to hold off to make sure you're comfortable with it, and then give it to folks maybe halfway through open enrollment, just so they have it. And of course, you're still using your benefit summaries and other material that's actually accurate. So. There's it wouldn't be a government regulation if it wasn't overly and unnecessarily complicated. They bifurcated the effective date of this SBC rule here. It depends on its application, or its effective date depends on when your open enrollment is relative to your plan year. So if you started in your open enrollment before September 23rd, then you don't have to give these SBCs to people who enrolled or re-enrolled during your open enrollment. But we're obviously past that now, and if for most of us, when we have a 2013 plan year, calendar year, the open enrollment starts in November or December, and so if that's you, then you need to get the SBCs into the hands of your employees by the first day of open enrollment. And then with respect to new hires, once the 2013 plan year starts, you should be giving them the SBCs once they're eligible to enroll in the plan. Any questions on the SBCs before we move on? Oh, I have another slide. Sorry. Drag you through one more because this is important. It actually makes it a little easier for you. In terms of distributing the SBCs, delivery to the employee will suffice as delivery to the spouse and the dependents, as long as the plan doesn't have actual knowledge that the spouse resides at another address. Most plans don't have this. I have some clients that are self-funded and they love information and they have this kind of info, and so then they were a little upset that it required them to actually go mail them to the spouses and the other addresses. But I wouldn't expect out of that most of you have that kind of information, particularly if you're fully insured. Yes.
What about all the dependents? So, now you've got kids up to 26 years of age covered under. Are you required to notify them, or is parents sufficient?
It's a great question. So the question was, again, what if you have adult children who are covered under the plan? Does delivery of the SBC to the parent of the adult child suffice? And it does, as long as you don't have actual knowledge that the child lives at another address. If you're aware that you have an adult dependent living at another address, then you should send in the SBC as well. Otherwise, delivery to the employee will suffice as delivery to the family members. And this also is true for electronic disclosures. So if your employees use email and in the internet as an integral part of their job, meaning that they have a computer at their desk and they can access your information system online, then they automatically consent to electronic delivery of these SBCs, which is a nice way of getting them out there. So for example, my law firm, all the lawyers, all the secretaries, they all use email as an integral part of their job, and so we all automatically consent to electronic disclosures. That works for employees. That's also the reason why we mail COBRA notices to the home, because the spouses and dependents, they cannot automatically consent to electronic delivery, and so therefore unless they've affirmatively consented, we mail things like COBRA notices to the house. So if you can distribute them electronically, we certainly recommend that you take advantage of that. There's a rule that operates in connection with these SBCs, and that's the 60-day advance notice rule. I don't know if you've heard about this one. it got some attention because we weren't sure how it was going to operate, but it basically requires the plan to give employees 60 days advance notice of any material change to the SBC. This turns ERISA on its head. Usually you can inform people after the fact. This changes it around, flips it around, but it's only with respect to mid-year plan design changes that are not made in connection with the renewal. Any changes made in the connection with the renewal are not subject to this 60-day advance notice rule. So a huge benefit there for employers. I mean, we thought that we're going to have to get the renewals done 60 days out, but that clearly is not the way this rule is going to operate, thankfully. Geez, I can't get away from these SBC slides. Generally, you do have to give it upon request, no later than 7 days. For new enrollees that are enrolling under a HIPAA special enrollment event, it's 90 days. That dovetails with the SPD requirement. You have 90 days to get the SPD to your HIPAA special enrollees. And this last bullet here is what Steve was alluding to. If the SBC can't be timely provided, you should just get it into the hands of the employees within 7 days of finalizing the terms of the plan. Moving on now to the W-2 informational reporting requirement. This is effective for your 2012 W-2s that'll be sent out in January of 2013. It only applies to large employers, and for this rule, we have a different definition of large employer for basically every rule. This one happens to be at 250 employees. It's a throwback to the old W-2 rules regarding electronic submission. The CPAs in this room are probably pretty familiar with that rule. But basically, as long as you have not produced or distributed 250 or more W-2s in the prior year, you are exempt from this requirement. And this is one of the only requirements under healthcare reform that does not operate on a tax control group basis. So if you're an employer and you're part of a larger tax control group, but you have your own EIN, then the 250 employee limit is based on your EIN. All the other rules under healthcare reform, like the non-discrimination rules and the employer mandate, all operate on a control group basis, so you can't get out from under them if you're part of a larger group. This one you can, and so if you have your own tax ID, then that 250 threshold is on a per tax ID basis. I think the toughest part of this whole requirement is going to be when employees get their W-2s and they see a bunch of new numbers on there. They're probably going to panic, and it's going to be your task to let them know that this does not mean that their benefits are taxable or that they'll become taxable. It's simply an informational reporting requirement that you're required to comply with. Generally, the reportable cost is the full cost of the coverage, like the COBRA rate, without the 2% administrative fee. So while it's intended to show employees how much the employer contributes to the plan, it's really not telling them that. It's just telling them the total cost of the plan, and they're left to back out their value of their own contributions. Not particularly useful, although I don't know how useful it would be to tell employees what you're spending on the plan anyway. But here we are. And that's pretty much it for the W-2 requirements. I'm happy to take questions on it, but you're probably working with your payroll vendor. If you have more than 250 employees, you send them the feed and they'll drop the information into the W-2s. One of the many tax increases under healthcare reform is this $2,500 limit on healthcare FSAs. Before healthcare reform, there was no statutory limit on health FSA contributions. Often the limit was $5,000. We had clients that had $10,000, $15,000 limits on their health FSAs. I had one client with a $100,000 limit on its health FSA. They just said, hey, you want to put it in? Go ahead. And we advised them that there's some room for abuse there. And what happened was they had an executive that was retiring, and he had a handicapped child, and so he put in the full $100,000 into his FSA, and he built handicap ramps through his house for his child, and then he retired in February, and beat the company out a bunch of money. And then the next year, you can be sure that their limit was back down to $5,000. But at any rate, so this is simply a tax increase. We were previously allowed to salary reduce in excess of $2,500, and now we're unable to do that. It's on an individual basis, so your spouse can also put in $2,500 to her employer's FSA. Even if you work for the same employer, you can still each put in $2,500, but it is a significant restriction. It'll be indexed by $50 increments starting after 2014. It does not limit employer contributions that are non-cashable. If you have flex credits, if you're still doing flex credits out there, and employees can take them in cash, it counts towards this $2,500 limit, so just be aware of how that works if you're still using flex credits.
Question, what if you've got a spouse that doesn't work? I'm going to be limited to the $2,500?
Yeah, if your spouse doesn't work, you're still limited to the $2,500, but if your spouse does work, then they can take advantage of their own employer's FSA, but you don't get to go to $5,000 if your spouse does not work. The big part here is just communication to employees, let them know their FSA limits are going to change, and we recommend that you amend your plans before the end of 2012 if you can, just to have the plan documented properly. There is a rule that allows you to adopt the amendment all the way until the end of 2014, but we just always recommend as a best practice, have the right limit in the plan documents, amend them as soon as possible, or as close to the 2013 plan year as you can. And this is effective for plan years beginning in 2013. So if you have a Health FSA that runs on a July 1 plan year, this applies for July 1, 2013. We originally thought it was going to apply as a 1/1, which would have kind of goofed everybody up with non-calendar year FSAs, but thankfully the regulators took some pity on us there. More taxes. We'll start with the smaller ones first. The Comparative Effectiveness Research Fee. This is also known as the Patient-Centered Outcome Trust Fund. It essentially is a $1 or $2 per member per year fee for everyone on the plan. It's per member, not per employee. And it's paid by the insurance company if the plan is insured, but it's paid by the plan sponsor if the plan is self-funded. This is a temporary fee. It's intended to sunset in 2019. I've read a description of this several times. I still don't exactly know what the money is going to be used for. The best I can tell you is to fund comparative effectiveness research, but you can see that from the title. It's very convoluted. But at any rate, it's supposed to sunset after 2019. We would not be all that surprised if this gets extended. And although it applies to all group health plans, including retiree-only plans and including grandfathered plans, it excludes most dental and vision plans, it excludes most healthcare FSAs, it excludes expat plans and other group health plans that do not offer significant benefits, like your wellness programs, EAPs, and disease management programs. One of the things that is a little bit unique about this fee, it applies separately to the insurance company and the plan sponsor, meaning the employer. We've seen in recent years, I think one of the ladies I was talking to has a plan like this where you get an insured plan from the carrier, and then as a company you self-insure down the deductible by using an HRA. So you might have a $5,000 deductible you purchase from the carrier, but by the time it gets to your employee, he only realizes, say, a $2,000 deductible. And then you do this through using an HRA, health reimbursement arrangement. It's becoming more popular. When you do that, though, the HRA is a self-funded group health plan, and it is separately subject to this fee. So the insurance company will pay the fee on employee A, and you will pay the fee on employee A. When you have an HRA integrated with a group health plan, and the HRA has more than a $500 annual benefit that's available to the employees. This fee will be reported on IRS Form 720. It may be filed electronically. The IRS has not updated this form yet, so if you were to pull it down off of the internet, you would not see any reference to the comparative effectiveness fee. It is not any plan years that end in 2012. Those plan years are the first year that this fee will apply to. But regardless of when in 2012 your plan year ends, you don't report until July 31st of the following year. So whether you end 12/31 of 2012 or July 1st of 2012, the fee isn't reported until July 31st of the following year. They give us a number of permissible methods to count participants. Some of them are only applicable to insured plans, and some are applicable only to self-funded plans. I think that the most beneficial method for most employers, since this is a per member fee, is to use this 5,500 method. And when you use the 5,500 method of counting, you basically take the employees participating in the beginning of the year, employees participating at the end of the year, and add them together, and those are your members. And I think it's, in most cases, the actual membership will be more than 2 times your employee base, right? So, you should test it out yourselves, but I think the 5,500 method, particularly for self-funded plans, and that's what we're concerned about for this fee, because the insurance company will pay it on the insured portion. But the 5,500 method is probably the way to go for those of you with self-funded plans or with HRAs that are embedded in the group health plan. Another fee, and this one is a little more than the $1 or $2 fee. This is it's called the Transitional Reinsurance Program. And when the exchanges come into effect in 2014, the government really doesn't know what's going to happen in terms of enrollment and adverse selection. They only have a few states to look at as a model. Massachusetts is one of them, and as I mentioned earlier, we saw significant adverse selection in the exchanges, in our version of the exchanges. So the government is prepared for that, and by preparing for it, they've decided to tax these self-funded plans that are performing well and build up a little reserve for the exchange plans. And so that's what this fee is. And you can see that we don't have a dollar amount here because we don't have the guidance from HHS that lets us calculate that fee yet. We've heard estimates anywhere from $30 per member per year to $120 per member per year. We simply don't know how much it's going to be, but it's obviously a lot more than that comparative effectiveness fee. It is temporary, it's only for a few years, but it could really have an impact on your budgeting for 2014. So obviously they'll need to give us some more guidance in advance of 2014, but it might not be until June. We really don't know when we're going to get enough information to let you all know how much this fee is going to be.
Will that per member be, you think, the 500 rule?
Yeah, I mean, who knows how they're going to count participants. It'll probably be similar to the comparative effectiveness fee rule, but again, we just don't have the guidance necessary for that.
Would HRAs come under this as a self-funded plan again?
I think so, but since we don't know how the fee is calculated, it might be off a percentage of claims maybe. So an HRA, I don't think is going to be hit with a fee of $100 per member per year, even if it's subject to those rules. It's probably going to be a function of what that benefit provides. So I think it's intended more for major medical plans, and actually I think I can do better than that answer. The fee is applied to TPAs. It's not applied to the plan. So the TPA is going to pay it on behalf of the plan. So if you don't use a TPA for your HRA, then it won't be included in this fee. but that's the way they kind of have this rule operate. They impose it on the TPA, and the TPA will obviously just pass it through to the employer. So this rule, this non-discrimination rule, those of you that have self-funded major medical plans are probably aware of this, the rule prohibiting discrimination in favor of highly compensated employees with respect to eligibility or benefits under the plan. This rule is in effect already for self-funded plans, and it was made applicable to fully insured plans under PPACA. It was originally intended to be effective in 2011, but it was delayed until further guidance was made available. There's no set date for this to come into effect, but we have heard that the regulators have been waiting on a bunch of mandates and guidance, or a bunch of guidance to release after the election. They were sitting on it because we think it probably wasn't all that employer favorable, but we can expect to see, now that the election is over, another wave of regulations coming out on some of these mandates. This could be one of them, where I'm hopeful that it's not. It is an incredibly draconian rule. It is one of the most severe rules under healthcare reform. As you know, as plan sponsors of fully insured plans, you can basically discriminate. You can have different classes of benefits, you can have different contributions for those benefits, and it is tricky to do that under a self-funded plan. It's possible, but you have to make sure that you're not discriminating in favor of folks who are highly compensated. And for this rule, again, every time we talk about one of these definitions, it seems to have its own definition for each rule. A highly compensated employee is one who's in the top 25% of your employees ranked by compensation. So every company will have a quarter of its employees be highly compensated. It's not like the 401k rules where you have specific dollar thresholds. Everyone will have HCEs if this rule goes into effect. And the reason that it wasn't applied to fully insured plans in the past is because the carriers have their own underwriting guidelines and state laws to comply with. And the avenue for discrimination is just not as great under a fully insured plan as it is under a self-funded plan. And I think that one of the things the Republicans were successful in doing in November of it was 2010 now, that they took over the House, I think that they were able to get this delayed. I think they made the voice of their constituents heard there, but this might be one that we see coming into effect in 2013. The penalty is pretty severe. It's up to $500,000 if you do this discrimination. It's $100 per affected employee up to $500,000. So just be aware of this one. We'll certainly be putting out information and bulletins on it if and when it comes into effect. I'm hopeful it will never come into effect, but we'll just have to wait and see. That actually is the end of my prepared remarks. I'm happy to take some questions, but I do appreciate you bearing with me through a somewhat dry topic.
Any questions for Stacy? Well, seeing none, I really appreciate you being with us here this morning.
Yeah, the question was, is there a methodology that will kind of tell you can look at and say, this is what my current design is and my current eligibility, and this is what I should be doing. Really, all it is now is it's sub-regulatory guidance that will let us know which of your employees will be considered full-time for purposes of the mandate. That's really the methodology that's available. And so if you have a lot of part-time employees that fluctuate plus or minus the 30-hour threshold.
And then we have a more comprehensive checklist that says that this plan applies with that too stingy, you're above the limit.
There's no checklist. I think the limit you might be referring to is the actuarial value
Right.
possibly. There's no checklist, although if you're insured, the carrier will tell you what the actual value is and if it meets the standard. If you're self-insured, there's that government tool that's not available yet. Hopefully it's better than the SBC tool that you can put in the pertinent claim designs, the co-insurance and deductibles, and it will give you a reliable measure of actuarial value, which is unrelated to the premiums. The actuarial value is only based on the plan design. Yes.
If you have an employee that's eligible for Medicare, can you exclude them from accounts for employers?
If you have more than 20 employees, you cannot take Medicare eligibility into account for benefits eligibility purposes, but they can't impose a penalty on you. So if your coverage in general is deemed unaffordable, then anyone who's on Medicare can't generate a penalty, although the other employees can generate a penalty. But you couldn't say, for example, we're only going to pay 25% of the premium for Medicare eligibles, and we'll pay 75% for everybody else. Those are the Medicare secondary payer rules that come into effect there for employers with 20 or more employees. Yes.
We've talked about fees and mandates and all kinds of things that are going to be imposed upon us. What do you see as a positive?
Well, I mean, personally, if the Supreme Court didn't find the Medicaid expansion to be unconstitutional, we'd have 50 million people in this country that would be potentially eligible for coverage. I mean, they eviscerated this law when they struck down the Medicaid expansion. Other than that, the medical loss ratios will, allegedly will require the carriers to provide more value for the dollar. All of the mandates, certainly if they were to affect our own families, I think we'd be thrilled that they were in place. Like the prohibition of PX conditions, the lifetime limits, coverage of age 26, all those are great from an individual standpoint. There really isn't a whole lot of these mandates that are going to bend the cost curve. If they do, it'll be 10, 15 years out as the rules regarding wellness programs start to take effect, and we see penalties up to 50% for non-participation in wellness plans. Those are the kinds of activities that are intended to bend the cost curve. That comparative effectiveness fee that I couldn't tell you much about, that's also one of the things that's intended to affect the cost curve ultimately, to figure out new ways for new treatments and things like that. So the question is, what if you have employees who have other coverage, whether it's VA coverage or spousal coverage? That coverage, if they enroll in it, will be minimum essential coverage, and that will prevent them from getting a federal premium subsidy, and therefore it can't result in a penalty on you as the employer if you're offering coverage. If you don't offer any coverage and they're full-time, then they'll be picked up in that $2,000 penalty that applies to all full-time employees. But if you're a participating employer, you offer quality, affordable coverage, and one of your employees declines to get it, whether or not he has coverage elsewhere, he can't impose a penalty on you. He can't trigger a penalty. Sure. So the question was, how does family coverage play into the affordability measure, that 9.5% number we talked about, how it's keyed only to the cost of employee-only insurance. that's the way the rule is written. They want you to provide or at least offer coverage to families, but as long as the premium for single coverage doesn't exceed that 9.5%, it really doesn't matter what the family premium is. And I would expect that companies that are going to get affected by this would probably adjust their premium contributions to make sure that the premium for single coverage doesn't exceed 9.5%. And by the degree they had to bring that down, they'll bring up the family premiums. And we're definitely starting to see that where it's not uncommon to have a very high employer contribution for single coverage and then a $0 contribution for family coverage. It all depends on how you want to affect your enrollment in the plan. We typically see like a 1-2-3 ratio for from an actuarial standpoint for risk management purposes, but you could certainly try to disincent families from enrolling in the plan by virtue of a higher premium contribution.
So you could pay 100% to adjust your employee coverage, and you turn around and say, if you want family coverage, then I can pay premium.
That's right. You could pay 100% of single and 0% of family, and there's nothing getting in your way of doing that. Unless the carrier has a rule regarding the premium contributions, but that usually is only for single coverage too, I think.
And one other question on that line, is that only related to the medical health? Not if you don't get to, I guess, include a county education dental or HRA or anything like that?
Right, that's the cost of single coverage. So you really can't include dental and vision in there. You can't include your HRA contribution because you can't have employee money going to that. So, regardless of whether you use an HRA, if the premiums for the coverage that's offered, whether it includes an HRA or not, can't exceed that 9.5% number.
When you mention premium, you always talk about the premium cost of the insurance, regardless of what the employer or the employee pays. Right? Compared to the whole cost. Total cost.
Well, no, the 9.5% is what the employee has to pay. When we say the premiums can't exceed 9.5% of household income, we're talking about the employee's cost of single coverage. Yes.
On the wellness differentials, do both sets of rates have to be under the 9.5% or just the wellness discount?
So the question is, well, what if we have a wellness plan that imposes a penalty for non-participation? That will be factored into the 9.5% as far as I know. So if you have a very significant penalty under your wellness plan and it pushes someone's premiums up above 9.5% of his W-2 wages, then he's in an unaffordable plan, even if he had the opportunity to avail himself of the wellness plan. That's the way I see it, given the way the rule is currently written. It would be wonderful if they were to factor in the wellness plan to that, but that's how it works under the grandfather plan rules, that a wellness penalty can kick you out of the grandfather plan rules if it results in a premium increase. So if this rule is consistent with the grandfather rule, then I would expect it to kind of work the same way. You got to be cautious that your wellness penalties don't push someone into subsidy territory.
Let's hear Stacy Barrow. Stacy, we appreciate you being with us. Safe travels back to Boston later on the day. I hope that storm stays off the coast there. So,
I'll come back tomorrow and talk about 55.
yeah, he likes Savannah. And TAC, thank you for getting the questions rolling here. Good to have all those. And to your question, TAC, in terms of where you are and where you need to be, that's where Seacrest partners will come in and assist you. The positives of this law, I think, someone were related to benefits. What keeps me up at night, and I think what concerns you, is all these underlying things in relation to regulation and taxes and the moving parts, such as maybe being grandfathered and staying within the 5% rule or the 20% rule. There's a lot of moving parts. This is the most comprehensive law, and I've been doing this for 30 years now, that I've ever been engaged with. So we want to help you through this process. It will be a process, but we have the tools and resources to do so. Stacy at Proskauer is a partner of ours. We work with him very closely. Other resources that we have actuarial resources through our association with Benefit Advisors Network. That's a consortium of agents throughout the country. We are the only one here in Georgia, but they're vetted out on a very thorough basis before you become a member of that organization. So we have a lot of resources through that. Another compliance tool that we have is Think HR. That's a tool that you can use as a plan sponsor. You can call a compliance counselor on the phone and they'll get you an answer for day-to-day type issues related to compliance. So we, again, thank you for being here. I want to thank Allison Heilser with Seacrest. This doesn't just happen. She put a lot of work and effort into bringing you here. And I also want to thank the golf club for helping us host this event. So safe travels back to work, and thanks again. We'll look to see you back here for our next seminar.